Friends, the big question under GST law today is that whether the input tax credit of the buyer of goods or services can be denied due to non-compliance by the supplier or retrospective cancellation of the GST-IN of the supplier by the department. The Honorable High Court at Calcutta on 12th June 2023 in a judgment in the case of Gargo Traders versus the Joint Commissioner State Taxes has held that in case the buyer can prove the genuineness and identity of the suppliers, and in case the buyer has valid documents to prove that the goods or services were in fact received by the buyer, then in these genuine cases the input tax credit of the buyer cannot be denied just due to a retrospective cancellation of the GST-IN of the supplier, or the fact that the supplier has taken fake GST registration or has indulged in certain malpractices with respect to the ITC taken by the supplier. Let us understand this case and the issue in detail. Now friends, under section 16 subsection 2, as it stands today, there are 5 conditions which the buyers of goods or services have to fulfill to take the input tax credit. First, they should have a valid tax invoice. Second is that from 1st of January 2022, the supplier should have filed its GSTR1 and the ITC should have reflected in the buyer's GSTR2B. Mind that from 1st of July 2017 to September 2019, there was no such condition of matching of input tax credit. From October 19 to December 2022, Rule 36(4) provided that the buyers could take input tax credit limited to a certain percentage over and above that reflected in GSTR 2A or 2B. So, from 1st July 2017 to September 2019, there was no such condition of matching of input tax credit with 2A or 2B also. Third condition of taking input tax credit by the buyer is that it should have received the goods or services, and the same has to be proved. Next, under section 16 subsection 2 clause C is that the tax with respect to the transaction should have been paid to the government, and input tax credit as self-assessed should have been taken in the GSTR 3B to be filed by the buyer for availing this input tax credit. The allegation of the department in these cases is that the supplier's GST-IN has been cancelled retrospectively. Let us understand with an example. Say you have purchased goods or services from a buyer in April 2018, and in April 2023 the GST-IN of the supplier has been cancelled retrospectively from 1st of July 2017. The allegation of the department is that since the GST-IN of the supplier has been cancelled with effect from 1st of July 2017, and because the GST department may not have got the taxes, therefore there is a non-compliance of 16(2)(c) and the buyer should be denied the input tax credit. Possibly the supplier has got certain fake input tax credit, or possibly the supplier has taken the GST registration itself on the basis of fake invoices. The Honorable High Court of Calcutta relying upon the previous judgment by the same High Court in the case of LJW Industries, and also relying upon the recent Delhi High Court judgment in the case of Balaji Exim, has held that where the buyer has confirmed the genuineness and the identity of the supplier by means of verifying that in the period when the purchases was made, the supplier has filed his GSTR 1 and GSTR 3B, where the buyer has the transportation documents, the invoices, etc., the e-way bill, consignment note, and most important, where the goods or services can be proved to have been received by the buyer in the said transaction, then input tax credit cannot be denied to such a buyer just because the supplier has made certain non-compliances and because the supplier's GSTIN has been retrospectively cancelled by the department. This judgment would come to the rescue of genuine buyers who are under hardship due to the non-compliance or the retrospective cancellation of the GST number of the suppliers. However, a word of caution here for the buyers is they have to keep their documents correctly. They have to ensure that the suppliers are genuine and identified, and most important, they have to keep evidences that the goods or services have actually been received by them. In case these are fulfilled, then this judgment of the Calcutta High Court in the case of Gargo Traders would certainly come to the rescue of such genuine buyers. Thank you very much for hearing out this video, and please do like, share and subscribe to this channel for maximum dissemination of knowledge. Stay tuned. Thank you.